Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today, we are discussing a case disposed by two judges bench of the Honorable Supreme Court of India. Judges Sanjay Kishan Kaul and Hrishikesh Roy, while disposing the case of and passing a decree of divorce in the case of Shivashankaran versus Sati Meenal. Shivashankaran versus Sati Meenal. In Civil Appeal number 4984 by 85 dated 13/9/2021 held that the marriage helicopter or marriage plane had a crash at the takeoff stage itself. They did not meet, they did not cohabit, they did not lead a married life even for one day for the past 20 years. So what is the purpose of making them move around the court? It is better to give them a decree of divorce. Already the divorce has been granted. But still, so the court held that the wife and husband had a crash landing at the takeoff stage itself. So these are the words used by the judge. Right. Please remember, what happened is, actually they were married. Actually this man, Mr. Shivashankaran, he is working as a professor also. Right. The marriage took place somewhere in the year 1985. Marriage took place, and actually the wife, that is Sati Meenal, on the pendal, that is marriage pendal itself, she stated that she was coerced or she was forced to marry him, and the marriage was arranged without her consent, and she left the marriage hall at the dead of night itself. So that's why it was called as a crash landing. Of course, as usual, the relatives, the parents and all of them, they tried to reunite them, but their efforts did not give any useful results, and their efforts proved futile. So ultimately, he filed a case of the appellant, Mr. Shivashankaran, he filed a case of divorce under section 13(1) of the Hindu Marriage Act 1955. For this, the Sati Meenal, she filed an RCJ petition, that is restitution of conjugal rights. That means she is willing to come back and reunite with him, right? But she stated that the appellant refused to cohabit with her. So the respondent's family was unable, that is her family was unable to meet the unlawful demands of Mr. Shivashankaran. That is her allegation. Ultimately, the trial was conducted after 5 years, maybe in the year 1990. The divorce was granted by the trial court as the marriage was broke down. So irrevocable or irretrievably broken down. That's all. But aggrieved by this, she went for appeal. In the meantime, after the so-called divorce, after the grant of divorce, after 6 days itself, this Shivashankaran is a great man. He married another woman. So this woman filed the appeal, and ultimately, incidentally, the appellate court reversed the order of the trial judge and asked him to carry on the conjugal life with this man. Now what about that second marriage? What about the woman? Already the first wife, Sati Meenal, she filed a case of 494 IPC, marrying another person, another woman during the lifetime of the wife. 494 IPC case also they have filed, and now the position of that woman, it has become in a dilemma stage, right? And therefore, this man, Shivashankaran, he went in appeal to the High Court against the orders of division bench, against the order of the High Court. Of course, the High Court division bench restored the decree of divorce. So once again, same as the trial court judgment, yes, it is confirmed, the divorce is granted. And now the respondent, she filed an appeal in the Supreme Court. Now, the Supreme Court, using the powers under Article 142 of the Constitution of India, thinking that the courts can dissolve the marriage when it is irretrievably broken, because 1985 the marriage took place till 21 years. There is no reunion, there is no chance. In the meantime, the respondent, she filed multiple criminal cases, she went to the college, she appeared before the students and actually defamed him insulted him in the front of the students and professors also. So, Supreme Court held that continuing such acts, they lead to cruelty on the part of this woman, on the part of the wife against the husband. So, taking into consideration the harassment and also irretrievable breakdown of the marriage, Supreme Court confirmed the decree of divorce under Article 140 of the Constitution of India. Of course, previously filed a case under Section 13(1), Subclause 1A, cruelty of the Hindu Marriage Act. So please remember, basing on the conduct of the respondent in the judicial proceedings, then at various stages, Supreme Court held that the marriage cannot be consummated, better to go for divorce. Good judgment. Of course, very recently Justice Lav Nageshwar and B.R. Gawai, they also gave judgment another such type of case. We will discuss this later. Here the main point is, so the plane had a crash at the takeoff stage itself. It cannot be landed, it cannot go upwards. That's why better to give divorce. This is the decision of the Supreme Court. Thank you.